to your honor and your glory. We thank you, O Lord. Amen.
Thank you, member. Members, we have apologies from member Roger Spencer, Dalrymple Filbert, Juliet Holness, and Dwayne Fass. And today we start deliberations on the Ministry of Justice. Just to indicate to members, we had at the start of at the end of the last session, we had indicated that on third Wednesdays we would allow the Parliament for the other, was that right? The other committees would have their opportunity. So it's not intended for us to meet next week, which is probably fortuitous because the quorum seems to be getting rather tight. I wonder why. Nonetheless, there's a speculation. I leave it out. But with that, so could we invite the Minister of Justice in? Sure. Is that better? Or is it the volume? Or is it the volume?
Mr. Tino?
Amateurs.
Morning, everybody. Pierce, how are you today? Good to see you. Excellent. All right, Pierce, what we will do is start certainly by giving you the opportunity to invite yourself, to introduce yourself and the team from the ministry and its agencies. And then after that, if you have any introductory remarks that you'd like to make, by all means, and then we'll go in. I think we have a number of the agencies. We had asked the Office of the Director of Public Prosecutions to attend. Welcome. Good to have you here. The Court Management Services and the Office of the Parliamentary Council. And to follow up, yes, and then not next week, but the following week, we intend, I think there are 3 more agencies. Is that correct? Yes, but we're going to put it off to the following week. Yes. Okay, so with that, I turn it over to you. Yes, what you could do is take both mics probably and just tune them in.
Am I heard now? Yes. Morning, Mr. Chairman and members. The Ministry of Justice and its agencies appear here, well, some of our agencies. The Central Ministry, represented by Carol Palmer, Permanent Secretary, Grace Ann Stewart McFarlane, Chief Technical Director, Anya Jones, Principal Finance Officer, Vivian Gordon, Building Projects Consultant, Property Management and Special Projects Unit, Chantel Ward, Director Budget and Commitment Control.
Yes, maybe a little indication by the members so that we can put a face to the names.
Oh, I'm sorry.
But continue, yes.
Immediately beside me is the PFO, Anya Jones. Beside her is my Chief Technical Director, Grace Ann Stewart McFarlane, and beside her is Ms. Ward, Director of Budget. And behind me, yes, is Vivian Gordon, our Properties Office person. The Office of the DPP is here, represented by the DPP herself. Mr. Jeremy Taylor, where are you, Jeremy? Yes. Mrs. Sharon Millwood Moore, yes, and Mrs. Simone McGregor Jackson, and that's 2 deputy directors of public prosecutions and their administrator and human resource manager. Then behind me, but to my left, is the principal executive officer acting, Mrs. Carol Hughes of the Court Management Service. With her is Mrs. Anne-Marie Cummings, her principal finance officer, and Mr. Terry Smith, building and property management. And representing the Parliamentary Council is Mrs. Erica Bozell Monroe, Deputy Chief Parliamentary Counsel and officer in charge of the department at the moment. Yes. Really, I do not have a prepared statement today, sir. I am prepared to move into the questions you wish to raise with us, and I will indicate whether I will answer or whether some other person will.
All right, thank you, Ms. Palmer. Members, just for the recollection of members, we had in inviting the Ministry of Justice to come.
Thank you.
We had specifically asked that one of the issues that was to be addressed was the issue of the court management system and the backlog of cases in the courts. The ministry has provided us with a report of the implementation of the backlog reduction strategy that is before members. All members have a copy of the report? I think a good place to start, and certainly I would invite the Director of Public Prosecution, certainly, you know, and PS yourself. I would like to just make a few, just to highlight a few points that came in the report.
Sure. Even though Madam Pierce didn't have a written opening statement, I'm sure she can give us a general overview of the ministry itself and and the sector itself. It's a general overview of how, from her desk, of how she's seen, even though she doesn't have a written. And I mean, we have the report here, but I'd love to hear from the state of the Justice Ministry from the PS herself before asking any questions.
Well, I put it.
Yes, Chairman, and I will address the first part of the backlog.
Well, I would like to.
Yeah,
to
as
say,
I
we
speak
can
to
come
that.
back to this after you have.
Okay. The Justice Ministry has embarked on a reform program, admitting and recognizing that the justice system is long in need of improvements, modernization, and to come into the 21st century. This was heralded by a justice sector reform study and a report from that task force in 2007. And our first focused works on this reform agenda commenced in 2009. We recognize we have a far way to go. The sector has been underfunded for decades, and so we also recognize there is an impatience in the public space, and we further recognize that there is a significant role that the justice sector plays in the growth and development of our country and the people being able to do business. Back in 2012, we sat, the DPP, if she will recall, and the Chief Justice, we sat and we worked out a strategy for dealing with the backlog. And we recognized in those discussions that it was multifaceted. It was something that no one entity could undertake, and that we were all involved, and the stakeholders in the justice sector also had a part to play. All of this had to be done with the sensitivities of the independence of the judiciary and the independence for prosecution of the Director of Public Prosecutions. So we had a very steep hill to climb, and we are still on our way. In addition to those functions that abide in those independent areas, there was also the state of the infrastructure. And not only has it been inadequate, for the simple reason that Jamaica has multiplied its population several folds since our court infrastructure was provided. There are other peculiarities that the justice system must address. For example, the work we're doing now with the introduction of technology. When the courts were built, technology was not part of the landscape. And so even where we have done works, those works are inadequate for the infrastructure required for technology to be introduced for us to benefit in the justice sector from the efficiencies there to be gained. Similarly, issues of victim protection, separate and considered positions in terms of security of judges, of court personnel, of victims in particular in our courts were not a part of the consideration. You go you go to the court, any court you choose, and there is very limited access. And I can think most courts have two, one at the back and one at the front. So everybody comes in, everybody mixes with everybody, and when you have vulnerable witnesses, that's a particularly problematic situation. And so we have, as I said, sir, a very steep hill to climb. The justice sector requires far more resources than it is getting. And yes, people might say, but you're not spending the money as you get it, and the challenges with spending the money is another problem. But the fact of the matter is that more resources of the human kind, of the financial kind, and of the physical infrastructure kind are required, and not to mention the technology that we are now introducing. I am happy to say that as part of the modernization is the creation of the court management services, which we are not very happy with how it's performing. It's public, minister has been public about it, and it is a fact. In truth, the Auditor General has been asked to do a special audit of the system because we have many questions, many problems. We felt that it should have been assisting us more in providing services to the courts than it is. And there may be a retort, there's not enough money. But there's not enough money to do anything, right? But you need to do the best you can with what you have. And so, as part of our further reforms, which I don't know if it's in the report, I can't remember, is we are seeking to reallocate staff from both the ministry and the CMS to the courts, because the courts need more personnel as we introduce these new measures. With the introduction of the technology, for example, we will need to have an officer who mans the system in the court to make sure it doesn't stop. If the judge needs annotation as the evidence is given, it is recorded there, and so on and so on. We will also, with the use of the remote production of evidence, so you have a video link, live link from somewhere, there will also be persons required to man that and to make sure the system doesn't fall down. And so, you know, in the best made thing, it's a man-made system, and so we have to have protection so that the system will work and the judges don't lose confidence and go back to writing by hand. That technology the preparation is underway for the installation of all of that technology that I just referred to. And we will have the installation of the equipment as we speak. For the DPP's office, we fought to increase the staff at the DPP's office because we are creating a unified prosecution service. So not only will prosecution be seen to be fair, but will be manifestly fair. So prosecutors will be separated from the judiciary, so there can be no thoughts that the judge is trying to influence the prosecutor or vice versa. In order to take on that responsibility, Mr. Chairman, the DPP's office needed more personnel. And so we fought, and I am happy to say on her behalf, though she can speak very eloquently for herself, we won the fight. The justice system, there are many things that we are doing which you would see in the reports. We tried to provide you with an adequate picture because there are just so many things that we are doing. And perhaps one other thing I would want to mention as a highlight is the introduction of the Mobile Legal Services Unit, which commenced its operations in January of this year and is providing, from the feedback from the people who they serve, a very wonderful and good service, and the people are fully appreciative. So, sir, with that, I will pause and hand back to you.
Okay. Member Paula? Tran,
Yes, thank you very much, Chairman. I do hear, Madam Pierce, the frustration that comes out, not only from yourself, but only recently from the Minister in relation to some of the issues that you have been pursuing. I wanted to just to ask about two areas. And you mentioned about the DPP and staffing, but the Minister in regaling the Ministry of Finance recently, I think he was focused more on other staffing issues. So probably if you could give us an update on that, and hopefully the answer is as positive as with the DPP. And secondly, just to speak a little bit about the use of technology in the courts, because you have explained just now that you are pursuing certain technological interventions. Probably you could identify for me in the budget this year where the spend will come, and what are some of the specific, you mentioned about reporting and judges not using longhand. So probably you could explain what technology we'll be using. Also, do the courts now accept payments using credit cards and other such new methods of doing transactions?
Thank you, sir. Your first question first. There has been a review of the staffing of the Supreme Court by our partners, the Department of Justice Canada, under the JUST program. That submission went to the Ministry of Finance. The court, with the introduction of criminal case management and all the other new initiatives we're doing, when that was reviewed, it was found that there were gaps in the submission. It did not address some of the areas. And so further submissions have been made to the Ministry of Finance, and we are working to have the Ministry of Finance address those. In the meantime, we are deploying staff from the ministry as we implement our own corporate profile that was done for us by the DOJ, which for the first time, the justice sector's ministry will reflect the functions that it has been given by the government. So what we're doing, and maybe some of it will be permanent, is we are seeking to see how we can improve the human resource capacity of the courts, both by way of review that requires new positions and upgrading of positions, because truth be told, for example, the organization of the Supreme Court has not been reviewed in decades. Yes? And so that is where the minister's frustration is. We need to get that settled so we can have an adequate human resource capacity in the Supreme Court. And when we're done with that, we're moving to the RM courts, now parish courts, I should tell you, because with the removal of the clerks of the courts from the works of the general working of a parish court, there are functions that will be left to be done by the other staff. And so that review has also to be done. Yeah? If I move on to your technology question, we're introducing live link, video link technology in the court. What do I mean? If you are a vulnerable witness, if you're a witness that is outside of the jurisdiction or for some reason you cannot be physically present in the court, the live link capabilities will allow you to participate in the process from some remote location. We're particularly proud of that because it will also assist in the participation of offenders who are detained to participate from their holding station in the proceedings until it comes to trial, at which point the individual will be brought to court. So we're looking at some savings in court time from that operation, issues of security costs, issues of transporting prisoners to court, which is a major concern in some of the delays we have in our courts. And the video recorded evidence, for example, if you have a rape victim and the police, after training, and that is going on, but that's not my portfolio, will take the evidence from that victim, and it is deemed evidence in chief, and so the evidence will be presented to the court by pre-recorded testimony. Not writing by hand, we are affording ourselves live digital recording of evidence. So the equipment will be placed in the court and it will record all the proceedings of the court. We require clerks now to be placed in the court to assist. For example, when people speak patois, that's a challenge that we have to overcome with the technology. When there are different kinds of issues that may arise, you can have someone who is making notes in the system, in the evidence as it is being presented, and allow for a full and true recording of the proceedings in the case. So that's the technology we are using. The provision in terms of the budget is under the EU, capital B, EU funding under the project Justice, Security, Accountability, and Transparency. That project is providing under component 3, I think it is, the Ministry of Justice. There are security components as well. The Ministry of Justice with technology infrastructure as well as e-CMS, e-court management system to deal with the records. So that's where the money is coming from for that work.
Pierce.
Yes, Chairman.
Just some clarification. I'm interested in the discussion about technology because I do believe that, a lot of the evidence that's given, and everybody's sitting down taking it manually. The fact that we can get video and we have tape and everything is far more. I don't know if it is your purview, but the extension of this, for example, about a couple months ago, somebody I know was in a car accident, and nobody was seriously injured. There were maybe 4 people, 2 in each car, went to a police station. It was a small police station. All 4 had to give statements. They sat down. 2 police were taking those records. Easily 4 hours. Just writing and the hold up of manpower, everything. And I was saying to myself, this is really more for insurance purposes or other issues of the nature. Are we extending that technology? Can't those be done, video or tape or some other thing? Are we looking at changing the legal parameters that allow us, because the amount of time that's tied up in these obligatory things. You meet in an accident, you have to report it to the police. You're tying up the police when they could probably be otherwise engaged.
What I'm aware of is that the police, well, Ministry of National Security, perhaps I should say, should be investing in technology as well. Because when I refer to the evidence as taken in chief being recorded and brought, that would be done in the police domain. But without making an offer, can I say?
Yes, absolutely.
The ministry, in light of our consciousness of the inadequacy of some of our court buildings to take on the electrical and all the upgrading works that's required, we have purchased some portable units. So, you know, maybe we could talk with M&S and see how we multiply the use and make them fully operational for this. I mean, this has never been discussed before.
Yeah.
But we are going to be putting technology and making it available, for example, for Horizon Remand Center. And is it Metcalf, Vivian? Yes, for Metcalf. So I think we can
shared
do
services.
Yeah, because we're also thinking not to put fixed units, but to use mobile units in those locations, because we're also conscious of the attractiveness of the equipment to those who have other intentions. So the issue of security of the equipment looms large in our thoughts, and
You'll
we
be
are
sharing it with the Ministry of National Security.
we are working on that as well. So it's major work, sir. I guess we are also guilty of not being too transparent with making the information available. But that's something I'm sure, given the ministry's approach to shared operations, we would be willing to consider.
Members, I don't know if you have some more general questions. I'd really wanted to move on to some specifics we'd asked about the court management. All right, I have Member Stewart had asked, and then Member Campbell. If you wanted to.
Mine is not contained in that document that you referred to just now, but through you to the Permanent Secretary. The Ministry of Justice has been pursuing what is known as the Derby policy agenda. Could you give us an update as to where we are with those 7 points which are mentioned?
We have moved on from the Derby agenda. We had achieved, I think, in the region of 60% of those matters. The ones that were not achieved were rolled over into what is called the Justice Reform Implementation Plan 2015 to 2020, which is recorded in the documents that we sent forward. So we are pursuing, that is the current reform agenda that the ministry is pursuing, which was approved by Cabinet, and in fact is our yardstick for the budget support coming under the 11th EDF for funding to be provided. We must achieve the various milestones, and the Ministry of Finance has agreed to fund us to that. So it's a costed plan, and it's under implementation as we speak.
Member Campbell?
P.S. Morning. I notice you speak to the issue of technology. And insofar as I recall, as far back as 2002, you put in place some proceedings to take place in the civil court, the civil registry, to include electronic filing of documents. Where are you? Because the last time I checked, which was perhaps January of this year, there was no electronic filing of documents taking place in the Supreme Court.
Thank you. That's correct, sir. There's no e-filing. The e-case management system, which is being evaluated, today is the final day, which is why my technology person is not here, will afford the courts e-filing in all matters. And it's one of the accomplishments we must attain by the 31st of March. What the court has been doing in the meantime, because we've attempted to get the technology and it has failed several times in our procurement processes. Fortunately, it's one of the things that the EU determined it would cover under the JSAT project, and the tenders were done, the bids were opened, and we are in the final stages of the evaluation. We are expecting that the selected provider will commence installation by January. And then a companion to that is for it to be able to speak to the prosecuting attorney's software. So in short, e-filing should be available in the Supreme Court based on our target and our indicator that we must achieve for the government to be able to pull down the next tranche of money under the 11th EDF. It must be achieved by the 31st of March.
Thanks, Piers. Insofar as the registry of the Supreme Court is concerned, can you say what role the CMS plays? Because we come, we hear these things speaking to how attorneys have experienced serious difficulties retrieving documents which are properly filed. One such report is that an order which was made by a judge from as far back as December 2014. Order properly filed has not been received by the attorney up to September of 2017. An order properly filed. The attorney appeared before the judge, got the order, and the order properly filed. Can you explain why it should take upwards of 2 years for an order which is properly filed to reach the hand of the attorney?
Mrs. Hughes.
Member, I'm afraid it's a question I really can't answer. It's something which does pop up from time to time, that we get complaints about certain documents that have not been forthcoming when they ought to have been. The court management services doesn't operate within the court in that way to send orders out. It's something that the court itself does. It's probably something which we could look at as to whether or not we would be able to assist there to help efficiencies.
Which takes me perhaps to the point where I want to get.
The ministry, I think about 2 years ago, in recognition of the challenges of the registry. The registry, the civil registry, because that's the one you're referring to, was transferred to the public building north, the expanded area of the Supreme Court. And we have provided them with high density filing to allow for better filing of the case files, because the challenge was, they said, they were chock-a-block in the previous space. That doesn't explain why it should take so long. But the registry is really within the domain of the registrar of the court, and therefore falls within the court's operations itself. So the ministry could not answer a specific detail like that, except though we say we are providing the enabling to the court to improve its efficiencies. But if you can give us the specific matter, I'm sure Mrs. Hughes would take it up with the Chief Justice.
Well, I'm not so concerned about the specific. What I really want to get to, which is the point. Let's just have, forget the individual matter. Where does the court management service come in so far the processes which are operating in the court? Do you have the stats to indicate to us, let's say a matter is filed on January 1, what is the average time it takes for a civil matter to be processed, to be dealt with for determination for a judge to rule on that matter? Where are you in terms of your average time for the completion of a civil matter?
I think in fairness to CMS member, I would have to get that information from the Chief Justice, because the ministry nor CMS doesn't get involved in the actual nuts and bolts of the processes of the court. So it will be difficult, now impossible, for us to give you that information just offhand. Mrs. Hughes can indicate whether she agrees with me.
P.S. Just following on what the member just said, I think that the point he made was a very critical point. For us looking on, we understand the independence of the court, we understand all of those things, but what we really are interested in is, if I have and we're not talking issues now of prosecution in terms of, we're talking civil matters was the point he made. If there's a case going before the civil court, one would hope that this would be dealt with in an expeditious manner, something put in place, and that the methodology, the way that we would be able to judge, to indicate whether or not systems are getting better or worse, is that you would have some sort of time, that it is taking us 6 months now, and then next year we'll put some things in place, it takes us 4 and 3, and what is the optimal amount? Now, it is, to me, I'm surprised to hear that we don't know, because it would seem to, not that, well, maybe not that we don't know, but that the ministry is not fully aware, because this is something that I would be using as a marker of how the reforms of the justice system are, the effect of them. So what I would suggest, you're coming back next year, next week after next, member, I think just following on what you said, I think that it's important for us to see, certainly with the civil courts, what the time is now, average. Some obviously would take much longer than others given the complexities, but there must be some time and what is being put in place to bring it down, and what are you aiming at? In other words, given the independence and everything, there is a general overall efficiency of the court system that we have to be able, we as a committee must be able to say that we believe that
I'll get the specifics
right.
for you, Chairman, but may I just say, the court has implemented improvements to the commercial court part of the civil registry, and they are now, and I just heard it last week and I don't remember it right now, they have established standards there, and they are doing much better, to the extent we were advised that persons with other civil matters are wanting to get it transferred to the commercial court. In pursuit of us
and those are, I mean, pardon my ignorance, but there is a difference between commercial and
it's a civil. It's a civil. It's part of the civil division. Yes.
No. So I would think that what you try to do is that the same reforms that have been so successful in the commercial court would be the ones that you would be instituting in the civil courts,
and that's
in the broader context.
Yeah, and that's what we have been advised, Chairman. But let me hasten to say we've taken on.
Sorry, when you say advised, It's because...
In other words, the record we have gotten, because we've engaged the services of a statistician in the courts, so we're now able to get more objective, accurate data from the courts. He was engaged last meaning 2016 May. So we are getting statistical reports, and that's an area of focus. But let me hasten to add, the commercial court is moving, so we have now taken on the divorce and probate of the civil court as well. And we had given the Chief Justice some assistance through the hiring of a retired judge. That has not worked as effectively as she wanted it, and she's asked me now to provide her with 2 legal officers, which we are working towards, so that the divorces, these matters, can be dealt with in the time standard set up in the law. Yes, so those are the next 2. And what is also required,
What is the there's a time standard?
Yes, you should be able to get. You should be able to get your divorce. I am advised within 6 months.
Well.
So, well, we.
And the probate.
And probate. I think it's 2 years, if I'm not mistaken.
So, do we have an idea of what the average time is now?
Oh, forever. It takes very long.
5 years. But I thought it was an attempted reconciliation.
For example, the amendments done to the Insolvency Act in 2014-2015, which removed the requirement of the Administrator General from going to court to participate in that process. And now those that fall to the Administrator General are dealt with by her. So if you will, and Mrs. Hughes wants to say something about divorce, if you will, we are chipping away at the civil division issues bit by bit, based on our resource capacity.
Mrs. Hughes, there are some members waiting with bated breath on the matter of divorce.
Chairman, I had reason to I had reason to speak with a member of the divorce unit just yesterday about the time it takes for divorces to go through. And she told me that right now they're at June, that is, they are putting through petitions which came in June. Now, part of the problem for the delays, a major problem, is the mistakes that come on the petitions, on the degrees, applications for degrees, NISI and absolute as well. Now, there are standard forms, but lawyers send these forms in with all sorts of variations to those forms. Okay. And they get requisition. She says that she did a full page and a half of requisitions to one lawyer, and those were additional to requisitions that had gone out before on the same divorce matter. And it's a problem that we have. So
the real issue is not so much the department.
It isn't. It isn't.
The
time that it takes. Yes, the errors that come in on the petitions and the applications for NISIs in particular.
Chairman, I'm sure Mrs. Hughes is not saying what I heard.
Why not?
That lawyers are dunces. They can't complete standard forms.
That's the truth. As a lawyer myself. Yes.
So that is an indictment on our law school. That's what you're saying.
No.
That we have lawyers who can't complete standard forms for their clients.
No.
And yours, what number would you say of those applications do you have going back for those requisitions?
Can I tell you, I used to be at the Supreme Court and used to do divorce vetting myself. And if I got a batch of 20, if 5 could go through without requisitions, it was a good day.
So you're saying 75% of the requisitions,
yes,
the
absolutely,
forms
sir.
coming in are incomplete.
There are times when I would get a batch
improperly-
and not one could go through without a requisition, not a single one. The problem is it's not always attorneys that do the forms, it's their clerks and so on, and they don't look at them.
But don't they have to sign it too?
They don't have to sign, no.
Well-
No, it's a petitioner who signs, it's not the lawyers. And you'll have, can I just tell you some of the errors? Sometimes it's a spelling error of the name. The name is incorrect. The petitioner's name is incorrect. The respondent's name is incorrect. The address isn't there. There are some standard
So just
phrases.
basic
Basic issues.
Is there any if these come with a certain amount of regularity, is there not something that you send out to the lawyer indicating that or is it anybody, meaning any organization, that you would say this is an issue? I don't know. Certainly in medicine and dentistry, etc., we have continuous education.
Yes,
I
we
don't
have-
know.
yes,
So
yes.
is that so in the legal practice? And if
Yes,
so,
yes.
would it not be something to advise these lawyers that are
Yes.
jamming up the system?
Yes, Chairman. In fact, last year, the Supreme Court had a CPLD, a continuing professional legal development course for divorces. In fact, the person I spoke to yesterday, I said to her that we probably need to do another one right now because these things are just jamming the system. They're taking so much time.
Yeah.
What about attendance?
I'm not sure how many turned up for the last one. I wasn't there.
That is the point.
Well, let me ask you a slightly different question. If I were to take in my petition this morning,
Yes,
everything in order,
right.
what is the average time does it take for you to dispose of a matter like that?
You could get the divorce absolute within 4 months, and that's because of the 6-week legal requirement between nisi and absolute. I don't think it can be done in under 4 months, but if you brought in a petition with no errors, the application for nisi with no errors, within 4 months it could be done, yes.
And how many of those would you say that you're getting presently? Because I understand that there's outside of the errors which you say are presented by lawyers, that there is some requirement that the registrars can't sign.
Yes.
And what does it take for a registrar, for us on this side or here, to help you to get to the point where a registrar, just an administrative act, because this is what it's at now, to be able to sign off on a divorce petition or, for that matter, a probate in the court? What would it take?
It's not the petition, it's the absolute that requires the judge to...
Yes, and I'm asking you now, what would it take?
It's a law. It's a law. It's written in the law that the judge has to sign.
Has to sign.
Yes.
So we just need to move an amendment to that
legislative
provision
change,
where the
yes.
registrar,
Yes.
so we don't have to have waiting for a judge to come back from Westmoreland to come to Kingston to sign a batch which she has sitting on her desk.
Yeah, that's right.
Or he, for that matter.
Yes.
And that is strictly an administrative.
Well, I don't know if it's.
Well, that's
I think there's the thinking behind it is, of course, that a marriage is a legal matter, and it's something which would require a judge to undo by under the law, but he's doing it.
Legal officer.
Yeah.
All right.
Chairman, in going forward, so what you would need us to do is to amend the particular provision
Yes, it would require legislative change.
to allow the registrar to be able to sign off on such a document.
Is this a suggestion that you would be in agreement with, or do you have concerns about it?
Yes.
Member, maybe what you are seeking is for them to make a consideration and bring us even a one page, just to see whether it is something that we could advance to the Parliament. We could ask them to bring it week after next. Okay?
Yes, sir.
Yeah.
Thank you, Chairman. Through you to Mrs. Hughes. Recently, there were issues in the news as relates to divorce cases. What measures have you put in place so as not to allow what transpired to reoccur?
I have noticed the head of the divorce unit walking with a big key. Whenever she leaves her office, she locks the door. If she steps out of the office, she locks the door. I hasten to add, though, that it's my belief that some of these fraudulent matters do not occur within the court. Some come from outside of the court. But I think it's best to wait on the investigations. Yes, but we have restricted access to certain documents, files, and at various stages, because there always is a possibility that someone will try to slip something in order to skip the line, so to speak. So that's the mischief that the head of the divorce unit is trying to cure by locking the door every time she steps out.
Members, before I move on to the issue of the management, which we had asked some specific questions, there's just 2 lines in your report on page 2, which, no, this is the brief, but it's in the report, but it says, well, let me just say, this is it says the Ministry of Justice establishment staffing is 277 positions, but 57 or 20% of these positions were vacant, including 19 middle and senior management positions. Is that those figures are not,
Some of the positions of the ministry, sir, are within the
but
new...
is that's within, the basic thing is about 20% of your...
250 is our total for the central ministry. And we have 203 for the other departments of the ministry, but that's not his question.
Still about 20.
We have several, I can't tell you the precise number now because we're actively recruiting, of our senior positions that have been advertised, and we're in the process of recruitment.
Okay. All right.
Chairman, may I just take you back to that divorce question?
Absolutely.
I would just want the committee to note that the ministry made an official request of CTOC to investigate the situation that we uncovered. That investigation is proceeding apace, and so far, 3 persons outside of the Supreme Court, outside of the operations of the justice system, have been charged, arrested and charged, and 1 officer of the Supreme Court, though not within the registry, the Chief Justice advises me, has also been arrested and charged. The police tell me the situation is continuing.
Okay. All right. Members, I just want to turn when the Ministry of Justice was invited to appear before us, we, as one of the issues that we had asked specifically was with respect to the backlog in the courts. And this is a long-standing problem, but something which it is in all our interest to try and resolve. And there have been a lot of discussions about it, so we ask that a report be tabled. The report is in front of all of us members, but there were a couple points that I think were important. I wanted to highlight them. And then I would ask the members present if they could just sort of tell us where we are. I turn to page 4, and it says in the circuit courts across the island, there are over 2,000 cases, with 861 serious offenses in the home circuit alone. In addition, there are over 35,000 cases in the several parish courts awaiting trial, some of them part heard. Criminal cases are overwhelming the courts, and with the best will in the world, they cannot all be tried within a reasonable time, thereby breaching the constitutional rights of the accused persons. Consequently, the Ministry of Justice response is twofold. One, the Ministry is responding by providing additional courts and provisions for additional staff. In the Supreme Court, the Ministry expects to double the number of courts available to try criminal cases from 6 to 12 courts. However, unless there is personnel to manage and staff these courts, they cannot operate. Cabinet signed off on an additional 17 posts, including 10 Crown Counsels, for the Office of the Director of Public Prosecutions, but to date, instructions have not been sent from the Ministry of Finance and the Public Service to implement this decision. Request has also been made of the Ministry of Finance and Public Service for the upgrading of existing posts in the courts and for additional staff to work in these courts. However, so far there is no agreement for the additional staff. In the meantime, it is the intention of the Ministry of Justice to shift staff from various agencies of the Ministry on secondment to the courts, pending additional staff being approved and provided. And secondly, the Ministry of Justice is placing great emphasis on an initiative started by the Chief Justice to have more accused persons pleading guilty, and they go through that. And then on page 5, coming to the conclusion, it says, it is also recognized that the circuit courts in Jamaica, where serious matters are tried, such as murder, rape, and wounding, will never be able to dispose of the over 2,000 cases waiting to be tried in the short or medium term. As the situation now exists, the courts will not be able to try all these cases in the short term. As for each case disposed of, there are several new ones being filed. This is not a very optimistic portrayal, and I think it's something that we have been looking at for a number of years, but it seems as if we are still not breaking the back of the problem. Could you certainly, one of the things that looking on again is you see sometimes in other countries where persons commit a crime, a few months later they're in court, a couple of weeks, they're either charged, released, whatever it is. It's a process. In ours, we're seeing cases 5, 10 years. And obviously, I mean, the saying, justice delayed, justice denied. What happens after 6, 7 years, obviously you're going to have a different type of case than if you had a fresh case. So the question of how we're dealing with it, well, I turned over to see if we could have a discussion, because I think in dealing with the issues of crime and violence in the country, if we don't resolve the issues of justice, we're really going to be swimming against the current.
Thank you, Chairman. And before I invite the DPP, I will just say this problem is not unique to Jamaica. It's probably the worst in Jamaica because of our level of crime and violence. The easy solution, and probably to have all cases tried in a reasonable time, is to have, and I don't remember, we did a scientific exercise statistically to see at the rate at which the cases come in, how long it would take us to get all of this done. And it probably would take the entire GOJ budget assigned to the Ministry of Justice to build more courtrooms, employ more judges, employ more prosecutors. It would not work. The simple solution would be to stop crime. That is eluding us as well. So, the Minister of Justice, myself, and this gentleman behind me, Mr. Gordon, we went to Washington in December of 2016. And amongst all the people we met a judge, now retired, who was a Chief Justice in New York. And he said he took the liberty when he heard we were visiting and he was asked to share with us, to examine Jamaica's situation vis-a-vis what New York was in his time. He pointed out to us that New York was where we are today in 1975. And they admitted that they would not be able to deal with every case by having a trial. So they intensified the use of alternate dispute resolution mechanisms, which is what we are intensifying here now. And they introduced and increased the use of plea negotiations to solve their matters. Their statistics show that up to 95% of cases in several states of the United States are now resolved before going to trial. So we are trying these additional methodologies to bring the crime, the ability of the justice system to deal with persons who are accused, to have their matters closed. It is impossible, given the number of cases, even if the country could afford to get more judges and courtrooms and prosecutors at an instant. Are those persons available? Are those persons with the requisite skills available to make that leap? So we view it as a critical challenge, and we have looked at other means to address the problem. So DPP, if you wish.
Good afternoon. Thank you very much. I wonder if I have the leave of being frank, Mr. Chairman.
Always.
Because, as far as I'm concerned, and we're not here in a blame game, but it is just unfortunate that over the last 30 years, there was not a unified, holistic vision by both dispensations, political dispensations, in respect of the justice system. And what is unfortunate, that a lot of the technocrats at the Ministry of Finance, under both dispensations, don't really understand exactly how the justice system works. For example, in the circuit courts, you can only sit in the rural circuits usually 3 or 4 weeks at a time per term. So if you are having 120 cases, and we're having quite a few of those matters because of criminal case management ready, as I always say, We're not dealing with law and order, where everything takes place in an hour. You can only try one case at a time. And when you are trying the case, all other matters have to be adjourned. Now, we are trying strategies in respect of the legislation, agreed facts, where we're trying to cut some trial time in half. We are trying to encourage guilty pleas. Certainly on our side, we are trying to make sure that decisions are made at an early opportunity after a few trial dates to dispose of a matter. But the fact of the matter is that unless you enhance the capacity of the courts, what you really should be having now is 2 judges, 2 panels of jurors, and all the circuit courts literally sitting for the entire year to be able to really break the back. If you look at our statistics, you ask for statistics from 2010 to 2016. Certainly if you look at the rural circuits, you will see over time the increase in the number of cases listed. What you will also see, which is not necessarily noised abroad, is the fact that for circuit matters, our conviction rate is very good compared to the acquittal rates. So I would say for the circuit court matters, over all the years, the convictions far outweigh the acquittal. But if you look at the disparity of the matters listed, convictions, acquittals, and the total number of matters dealt with, you'll find that there's still a big gap in respect of the matters that are actually tried or where people plea, because you just don't have the capacity in the system. And that is the bottom line. At least 40 years ago, there should have been a 20-year plan, a 30-year plan to take account of the increase in the population in the town centers, the increase in crime. Even looking at our statistics, you will see the doubling, the tripling in crime in many of the parishes. And this will happen. I just came back from an International Association of Prosecutors conference in China, which is over 100 countries. And most prosecutors from all countries, including Canada, we all have the same problem in terms of having a backlog. It's a question of how you minimize it, I can assure you. But part of Jamaica's problem is the fact, and I say it, that the justice system has never really been as sexy for you legislators as building a highway. Therefore, the resources have not been put in place over the last 30, 40 years to enhance the capacity of the courts. We are going to be trying a pilot project in St. Catherine Circuit, which is now recording over 300 cases. Over 400, thank you, Jeremy, over 400 cases for St. Catherine. I think at least, well, most of them are sexual offense cases. So in conjunction with the Chief Justice, we have decided to find the resources to have 2 different circuit courts sitting at the same time from beginning of November through to December. 2 different judges, 2 different jury panels, and we hope that the Defense Counsel will cooperate. But in order for us to mount those 2 sittings at the same time, Mr. Campbell, you would understand, as a criminal lawyer, we have had to collapse the continuing sitting of the Clarendon Circuit Court. So it means that matters that would have been ready for November and December, we have had to adjourn those until next year so that we can have a judge and a prosecutor available to try to break the back of that over 400 caseload. And this is where we are. So the infrastructure, as the permanent secretary, trying not to show her frustration, but as a chief technocrat in the ministry would understand and has told you, the lack of enhancement of the capacity of the court system for the last 30 years, we are now reaping the whirlwind. So a lot of us in the system, we try our best, working night or day, but you have now reached a stage in almost all of the circuits where every day we have matters that are ready, witnesses are there waiting, and we have to adjourn them, because unless you're going to plead guilty, once you start the trial of a matter, well, certainly in home circuit, where you may have a matter going on for a week, 2 weeks, 3 weeks, nothing else can be tried in that particular court. And we still, in home circuit, only have 4 criminal courts. But we are eternal optimists, and I believe that members of the defense bar are also recognizing that agreeing to, consult with us in respect of where we can have agreed facts, so that if you have an indictment with 7 witnesses, if we agree some of the witness evidence, we can go with maybe only 3 or 4 witnesses. That will cut the trial time in half. We are finding a greater buy-in in respect of criminal case management, which is judge-driven, where the judge encourages, forces both the prosecutor and defense counsel to understand and recognize what are the issues. Let us not waste time. So we set it for trial, and we cut out the fluff. And we have these sort of measures. Tomorrow we're going to have sentence reduction day in the home circuit court, where at least 15 persons will plead guilty. We're going to have it in the St. Catherine Circuit Court on Friday. And so important is it, Mr. Chairman, that I am going to be conducting the prosecutions in the court tomorrow to take the guilty pleas, and I've assigned Mr. Jeremy Taylor, Senior Deputy Director, to go to St. Catherine, in addition to the fact that we are very stretched. So it's all hands on deck. Yes.
So I think from what you have said, this is a perennial problem. And
it's a perennial problem,
we understand
because
that.
the Parliament did not recognize. It's really systemic.
Yes, which
It's
is
systemic.
the point. So the question though is, when you read the report really says that there is a backlog, and it is the strategies to address this backlog.
To attempt to address it.
Right. There are two things that are the backbone of this strategy.
Yes.
Number one, increased courts. And it goes on to say, however, in increasing the courts, you also have to increase the staff. And
Definitely.
while that has been approved, it has not been realized. No, so that's number one.
Well, we have had a change of circumstances where that is concerned, because the DPP's office is now in receipt of approval from the Ministry of Finance, where we will have at least 16 new positions, new posts for legal staff, and an upgrade of at least 19 posts for the administrative staff. So we do have that, and we're presently seeking to fill those positions.
So the point, so number one would be that, and number two, as you said, the increased use of plea bargaining.
The increased use of plea bargaining, as well as the agreed facts. But even with that, even if we increase our staff, you would still need to have an increase of court reporters. You need an increase of the clerical staff in the courts who represent the registrars.
Yeah, but the question I'm trying to get from you,
yes,
is that you have gotten an increase number, what it seems like, legal staff.
Yes.
But you're saying that without the concurrent increase in the
courtroom capacity,
legal staff, the administrative,
right, and
that
courtroom
this is
capacity,
not going to courtroom capacity.
Yes. It is still going to be challenging it is still going to be challenging, but we are hoping that, well, we can only try.
What is, at present, what would be the average time for a murder trial? What would be the average time for that?
I'm going to ask Mr. Taylor
if one of
to
my
answer that.
members,
Yes.
well,
I'm going to ask Mr. Taylor to answer that.
Yeah, because I think I'd like to know because that's what people watch often. Is that coming down? Is it increasing? Where are we at with regard to that? Serious crimes, murder, rape, etc.
Very well, Mr. Chairman. The time varies, and if you forgive me if I go through it like this. There are 3 courts in Kingston in which murders are tried. So the more complex murders are tried before the senior judges in Court 1 and Court 2. And so senior prosecutors try those matters. In those courts, the kind of murder case that is there can run to 2 to 3 weeks. Or even 4 weeks.
That's the length of the trial.
That's the length of the trial.
Okay.
If I go to the other court, Court 3, which is where you get, I don't want to put it that way, but it's a basic murder, it's a stabbing.
You want to just clarify the difference between a complex and a simple
usually,
murder?
two persons are fighting and so on, and a stabbing. So that can take you the entire 5 days inside that court. Sometimes it may take 4 days, but that's the average that we have managed to work out. So when we're blocking trial dates, we have and it's part of criminal case management, we have to tell the court how long we think this case is going to last for. I know that my learned friend, Mr. Campbell, is quite familiar with that. We have to tell the court how long the case is going to last for. And over experience, an experienced prosecutor can look at a file and say how long. So in, for example, Court 1 and Court 2, you are looking at indictments which have close to anything like 14 to 22 witnesses. And that is partly because how the matters are investigated. So as the cases go on, the police use more and more investigative techniques. So they're becoming more and more scientific, more and more forensic. So you're getting DNA, you're getting cyber, you're getting gunshot residue, you're getting all kinds of things, video, CCTV, and all of those things. And although there has been some improvement in the law of evidence still requires, one, I must establish the provenance of these things. That's how did this evidence come into being? And then I must establish its integrity and authenticity, which can usually take just getting the evidence in, for example, a cybercrime case, or getting in computer-generated documents in, can take a good period of time, and that is just one aspect of the evidence in a trial.
My question wasn't so much how long the trial would take. I was more referring to how long, if the crime was committed in October of 2017, when do you expect that to reach judgment?
Right. Well, Mr. Chairman, again, I will piggyback on some things that the learned director has said. If you look at the island as a whole, for example, there are 3 continuous circuits in Jamaica. Let me just give this as a context first. There are 3 continuous circuits in Jamaica. That is the Home Circuit Court, that is St. Catherine, and that is Clarendon. Home Circuit has 800 and odd, St. Catherine opened with 430 odd, and Clarendon, I believe, have 150 odd. All the other parishes have 3-week circuits. And 3 of them are burgeoning at the moment. St. Anne, which has over 150 odd, being tied with Manchester, which has about 150 odd, and St. Elizabeth, which has over 120 odd. So, in a sense, we've been having to send, for most of the island, we've been having to send 2 Crown Council to go. It's only Hanover, Trelawney, and Portland so far have manageable numbers, but their numbers are growing. So if a case, if the police arrest and charge somebody today, the first port of call is not even a circuit court, it's a parish court. So it has to stay there, it has to go undergo committal proceedings. So once that is completed, it is then committed to the circuit court. It has to join the line. And the cases are prioritized, so you look at terms in cases of age, how long has it been before the court? Whether the person is on bail or in custody, whether or not you have a vulnerable witness, a child, somebody who is on the witness protection program. So when we have the 860 odd cases in the home circuit court, already in the pipeline before anything has joined, these are the decisions in terms of managing the cases. And it sounds away, but we have to decide who is going to get tried before who. And the older persons in custody and so on, those are going to get the priority over anything new that is coming in.
All right. I hear what you're saying, but from my perspective, though, just looking on, it seems to me that the average murder trial, just the ones that we see, 3, 4, 5 years minimum to really get. Is that the? I'm trying to get. Is that the norm,
Chairman,
or is it 6, 7, 8?
I'm going to say it varies, but yes, I will say that it will take years. If I go to, well, I see 2 members from Manchester here. If I go to Manchester right now and have a case in the Manchester courthouse, any case that is going to, and I hope a new one will be coming on the line soon. If any case that is joining, is coming in now, is not going to be tried either in 2017, in 2018, or 2019. Wow. And sometimes cases languish on the list because prosecutors make the decision, either can I get a greater quantity of cases off if I don't do this murder matter, which will take the entire 3 weeks. So you can easily have a situation where you do one case that eats up your entire circuit and you don't do anything else.
Yeah.
Pardon me? It's rather an incentive.
Yeah. The point is that, again, I think we're all, and as I said, we're all concerned because that's one of the problems. When you have somebody who is allegedly commits murder or whatever, and 3 years, 4 yees, everything differs. You know what happens with the witnesses, everything, it becomes an issue. Don't we have something where we put special court in place just for that? Or is there something we're doing understanding that we have a particular problem?
With the greatest of respect, this is why we have to go back to the genesis of the problem.
And Chairman,
the fact that the capacity of the courts were not enhanced as part of a national plan where both political parties bought into it as a priority from over the last 30, 40 years. So those of us in the system, we have to do the best that we can with all the lack of the resources. And this is where we are. It is not like what you see on television. Even American prosecutors laugh when we are together and say, unfortunately, a lot of people look at cases like Law and Order or CSI and think that's what happens in real life. It doesn't work that way.
And may I, Madam Director, just to, again, if I may just use a couple illustrations which may give an idea of what the problem is like. Let me use the Manchester courthouse again. The Manchester Circuit is sitting now. The courtroom in which the Manchester Circuit Court is being held, it means that there's a parish court that is not sitting. It means that the list in that court has been put off before another judge. Let me go to St. Elizabeth in the neighboring parish.
And to help you, sometimes you have to move out the administrative staff to make additional courtroom.
Well, there you go. In St. Elizabeth, there is only one courtroom. And so when the circuit sits in Black River, they have stopped having the parish court sit in Black River. Before that, the parish court used to sit in the bailiff's office. And in fact, in St. Elizabeth, the custody persons and the jurors share the same room because there is no holding area. So when you need to make a submission in law, when you need to make a submission in law, when the jurors need to retire to consider a verdict, you have to empty the room of the custody persons and put them to sit in the court while the jurors go in to deliberate. That is a courthouse stock that we have in St. Anne. Again, when the circuit sits in St. Anne, which it is now, again, a parish court has been displaced, and you have not lived until you enter the St. Anne courthouse to see police fingerprinting persons right in front of a courtroom door, and a holding area which is under a staircase, and in which I share the same bathroom with the custody persons.
But Mr. Member of Parliament, you see, part of the problem is that the legislature of both political dispensations have been in a bubble where the administration of justice is concerned. We are in the trenches, but part of the problem is that a lot of you really don't understand what it takes to run the justice system. So a lot has been taken for granted. So the courtroom stock has really not been enhanced with the requisite resources as it should have been. And I understand from the permanent secretary that our donor funders do not fund infrastructure. They have been very good in terms of, for example, the IT requirements and the equipment. So there is nobody, unless it is going to be the government of Jamaica, whether under the JLP or the PNP, to decide to have the will to treat the justice system in the way that you would highways and that sort of thing, and really put some resources to improve our courtroom stock and to have a unified, it should be that both parties have a unified vision, a holistic approach over 20, 30 years in respect of how you resource the justice system in light of the fact that you're going to have an increase in population, you have an increase in crime.
And if I may, Madam Director, if you're speaking about courtroom stock, remember the most recent courthouse that you have built is Balaclava. Before that it was Portland, and long before that it was Lucy. All the other courthouses are well over 100 or going to 200 years old.
Mr. Chair, that's a question I was coming to. The Balaclava courthouse, how much is it being utilized?
The Balaclava courthouse, well, it's an outstation, so it doesn't sit often, but when the special sittings of the gun court are held for St. Elizabeth, it is used. So it has been used regularly in the summer, every year so far, I think, for gun court cases.
My impression is that it is being underutilized.
Pardon me?
My impression is that it is
Utilized.
Well, it is underutilized because, as I said, it is an outstation.
It's a beautiful courthouse.
It's not a main station, so that court technically sits only at certain periods during the month. I'm trying to remember if it's like once a month or twice a month ordinarily. So it gets only a lot of use when we have the special sittings of the gun court in the summer.
Yeah, but I'm saying maybe you could look into,
The main station for St. Elizabeth is actually Black River.
Yes, I know.
And the Balaclava courthouse is miles better than the main station.
It's one of the best in Jamaica.
But still MP.
I also want to raise another question, Mr. Chair.
Sorry, I don't think Mr. Witter had finished.
Yes. Could you say how much the investigative ability of the police impact your dispensation of justice? Because I'm aware of cases that are brought before the court by the police from time to time, and they would tell the judge that we're not finished with our investigation, yet it is before the court. How does that impact your ability to dispense justice?
It has an impact. I will tell you. Evidence is our stock in trade. The police gather it, prosecutors present it, defense counsel attack it, judges and juries evaluate it. And so a lot of the case has to do with how is that evidence. Now, unlike what many people may think, prosecutors can't manufacture evidence or magic. We have to work with the evidence that we have. And I cannot deny that there are times, many times, that there are evidential shortcomings in the way how cases have been investigated. And sometimes it is true that the police are quick to put a person before the court,
And that is my
before substantive and material investigations have been done.
What do you do in terms of letting the police know that
The police already know. The police already know.
Huh? No.
Ms. Llewellyn.
Yes.
Could I just say, that is so, but you have had many instances where we have seen excellent investigation. The witnesses are available, everything is ready, but because we don't have the court space, we have to keep putting off the matter time and time again. The police get frustrated, the witnesses get frustrated. Well, that can be fixed because on occasion you can go to the highest level or you can ask that a warrant be ordered if they were warned. But it still doesn't stop the fact that sometimes it doesn't stop the case from being tried because sometimes the evidence of the police officer is formal. But what we are looking at now is that we are getting a lot of the cases ready, but you have to be telling the witnesses that a matter is in progress, and with the new committal proceedings, I'm on record about the tsunami. So it's more cases coming into the system, certainly at the circuit court level, at a faster rate with the same number of courtrooms that we have had for the last 30 years.
Mr. Just a question, just for clarity.
Yes.
You mentioned, for example, Manchester, when the murder trial is going on, or the other circuit lockdown.
Not all this.
How many courtrooms?
The parish court, because the room that we're using for the circuit court, it's really a parish court room. So when the circuit uses that courtroom, there are cases that have been set for that court which can't be heard.
But what I'm trying to get at is, I'm just trying to clarify in my mind the information. How many courtrooms do you have in Manchester?
I think it's either about 3.
Well,
I think it's 3.
What we have here, I just say what we have on the list here, it says Manchester Courthouse 3.
3. There are 2 upstairs and I think 1 downstairs.
Then it says.
Sorry, Chairman.
It then says, yeah.
There are several courts.
But that's the point I'm getting at. That's the point I was getting at.
And the use of the outstations has been encouraged for years. There is a tendency to have a focus on the main court, which is where, when the circuit sits, it must get priority. Yes? So, as Mr. Taylor said, the inadequacy of each parish. In other words, we do not have a Supreme Court room designated as such in the parish. And the Chief Justice will tell you she would love to have the circuit sitting all year round so that we can dent the number of cases. But it's not practical because the 99% of cases that are at the parish court will therefore not happen because the outstations, though most of them are as derelict as they come, despite the repairs that are done, they are just too old and they cannot manage what is expected of them. So we really have a big problem with the infrastructure, the physical infrastructure of the courts. And there is not an appreciation, nor understanding of the fact that there are different types of matters that must be dealt with in a court.
Ms. Farmer,
So yes, we have courtrooms in Mandeville, we have courtrooms in Cottage, one in Cottage, we have
But
one in...
But you're preempting the point. In listening, I heard that, you know, when the Manchester is sitting, everything else stopped. I heard. So my point is, but when I look, please, when I look at the report, what I see here, Mandeville Courthouse, 3 rooms. Porous Courthouse, 2 rooms. Cross Keys Courthouse, 2. Spalding's Courthouse, 1. Christiana, 1. Cottage, 1. That is 3 and 2, 5, 6, 7, 8, 9, 10 in Manchester. St. Elizabeth had 2, 4, 6. The question I'm asking is, the impression we got is we were dealing with only the main courthouse. We just want to know, what is the situation? Is that being utilized? If the main courthouse is being used for one, are the others used for other things as well? It is just for us to get a better understanding of what is going on.
If I may,
Chairman, truth be told, there's an underutilization of the outstations.
An underutilization.
Underutilization. And
then
a few months ago, when we visited St. Elizabeth, for example, and we went to Santa Cruz because we were told the older courtroom was not being used because there was no air conditioning. But we had put in 2 brand new air conditioning units in the courtroom. And so we went there, it was empty, the air conditioning units were on, and we were the only people who happened to go into a very cold room. And
but then why would that be? Whose fault? Who is supposed to be setting the itinerary, the agenda for meeting in those courtrooms?
The courts, sir, the courts.
So
the ministry can only work on the improvements as best we can, given the resources, to the plans that we have. It is the courts that has to set the fixtures.
You know, Ms. Palmer, the problem we have is when we are sitting here and we hear from the DPP that, you know, there's a perennial problem on both sides. We agree with you that there are issues, but where work has been done and it is not being properly utilized, that is an even graver problem.
If I may, Mr. Chairman.
Because you can't keep coming and saying that these problems exist, and yet when the facilities are made available, they're not utilized, and yet you're still saying that this is the reason why we're not addressing the backlog.
We're not
optimizing what we have.
No, but Chairman,
if I may, Mr. Chairman,
they are dealing with their level of matters. They don't operate at the parish court level.
Yeah, but
so they are talking about the challenge of having enough courtrooms to deal with the circuit level matters, which is a fact. That is why we are working on the Supreme Court right now. We are about to hand over to the Chief Justice.
Yeah, but Ms. Power, what was said to us is that when they utilize one of the courtrooms, it blocked off the others, and so their list was growing. So unless I understand
that's
incorrectly,
a practice, sir. That's a practice.
I'm saying if these courtrooms are available.
If I may, Mr. Chairman, I'm sorry if I gave that impression. Let me go over the illustration again. When the circuit sits in Mandeville, it is at the head station. So it's one courtroom in Mandeville that is taken out of service because that one has a jury box. It does not affect the sitting of the outstations. So whether it's at Grove or whether it's at Cottage, the outstations will sit at their regular times during the 3 or 4 weeks that the circuit is there. I must say, however, Mr. Chairman, it's not easy, however, to transfer matters from the head station to the outstation when when the circuit is sitting, because our experience has shown, especially when the circuit sits, to get witnesses and jurors sometimes in many of these rural parishes, there is a cost factor. So for example, and I can speak because I used to go to the St. Elizabeth circuit quite regularly. Jurors and witnesses complain about the cost of travel whenever the circuit sits in Black River. So the jurors who may be coming from places like, not as near as Junction, which is probably clear to, they could come far as Siloa and everywhere, still have to come down to Black River. When the circuit opens and the judge asks any reasons why you can't serve, everybody puts up their hands and they say, well, you know, the cost factor is prohibitive. There have been instances in the past where Crown Council and very well have had challenges, you know, but certainly in relation to witnesses attending, we have had to find ways to get them. So it's either we have to get the police, the one car at a police station in country to bring the jurors to come down, to bring the witnesses come down, and then to collect them at the end of court and carry them back. It is not easy. In fact, if I just use St. Catherine is lucky. St. Catherine has a dedicated space for a circuit court, and in fact has another courtroom if 2 judges are to come, that it can be used without doing any great displacement. And we couldn't even send the Spanish Town cases to the outstations in St. Catherine because Linstead sits every Monday and Wednesday, and Old Harbour sits every Thursday and Friday. So you could not send the Spanish Town case, say they didn't have that dedicated courtroom. You could not send the Spanish Town case. All you'd be doing would have been compounding a problem if you sent them to go to Linstead and Old Harbour.
Also, you have to look at the security aspect of running a court. In most of these outstations, I don't know if any of you gentlemen have ever been, most of us as prosecutors in the High Court were clerk of courts. So we had to work in the outstations. You cannot have a situation where you have, for example, a number of custody people, and you would take them to the outstation where it would be a high security risk because of inadequate spatial provisions to really house custody persons. You'd be asking for police officers.
But Chairman, and that comes back to the Manchester, come back to Mandeville.
Yeah.
Because Mandeville, they have to cross the road from the police station to come over to the courthouse.
Yes.
There's no holding area at the courthouse. Yeah? And I'm very interested in what is going to happen to Mandeville, because I know that you've been looking at space in the parish of Manchester.
Yes, I think.
And the courthouse itself is inadequate as is. It's a historical site, so it's over 200 year old. It is deteriorating rapidly, and that security issue is also an issue. We saw it with the pastor. We have seen it right across the period, especially when you have high-profile cases.
And guess what, Mr. Member of Parliament? You read about it. We live it because we are right there in the courtroom. We are right there. So it's very hard to explain unless you have actually been in it. To you, yes, there are these several courts, but you don't know how it is configured, what it needs to be retrofitted, and the fact that with a list of over 150...
Being a lawyer, I hope I don't have to see inside of the courtroom, so I'm fine being on the outside.
Member Paul, well, no, you've been...
Chairman, I find that because I behave myself and
I know
join the queue,
you find that
you
find that the queue is ever
skipping me. But Mr. Chairman, it brings me back to the role of our committee, the PAAC, because we've heard very convincing statements by both the Permanent Secretary and far more passionately the DPP on the state of affairs in our justice system. And I know the DPP has chastised us for not seeing the priority that justice. Yes, and I know you're being even-handed in the criticism. Earlier, the permanent secretary, she's given justice. The permanent secretary mentioned about the Ministry of National Security. Our number one problem in this country is law and order. And I think as a parliament, we have to be clear that this is priority number one. And you can't be focusing on crime without justice. So they are inextricably linked. And perhaps, Chairman, it could move our colleagues if we were to make a definitive statement from this committee based on the submissions that we've heard today, that we have to now carve out in all the priorities that we have, education, road construction, and so on, carve out this area as the one that we focus on to deal with, because without that we're not going to get growth, we're not going to be able to have the revenues to build the roads and so on. Crime and violence is the number one problem, and if we don't sort out both together, justice and national security, we are doomed. So I would strongly recommend that one of the recommendations today is that this sector be the priority sector going forward, and that we have to find a special project that the budget will support that will holistically treat with justice and security.
Well, that is music to my ears. However, unfortunately, we cannot, and I've said it before, we cannot block road and demonstrate. I've heard the words, but as far as I'm concerned, I will exhale when I see the action.
Yeah, you're going
Well,
back to Mandeville, right?
I'm glad that you have said what you said.
Before you go back to Mandeville, I agree wholeheartedly with what the member from East Kings and Port Royal said. However, we do recognize that there are budgetary constraints which affect everybody. And so it's not a wholehearted thing. What I'm a little concerned about, what is happening to me, is I'm trying to define to myself certain specific areas where maybe the financial intervention could make a significant difference, rather than just across the board. We need, so if we need more staff, we need more courts, we need et cetera, et cetera. Are there any specific issues? You know, we had a long discussion on technology. I think we all agree that there are areas where it could make that difference, but what is it? And you, Pierce, I think this is where it really comes to. What are the specific low-hanging fruit that really could make a difference, that we could go to our colleagues in the House and say, look, these are things that we think can make a huge difference?
Chairman, we have outlined the low-hanging fruits that were in the reports that we are after. The use of alternate dispute resolution to solve matters is something that we're pursuing. We have set up the first Justice Center. The next Justice Center is going to be Buff Bay Courthouse, that we have the agreement of the Chief Justice that we can utilize that court. Large 2-courtroom courthouse that's underutilized. We're going to be providing restorative justice, child diversion, and mediation services from that facility. We have gotten our agreement from the post office to use some of their non-use spaces so that we can divert matters from the court into alternate dispute resolution. And you may recall I said earlier, in a lot of jurisdictions, this make a significant contribution to reducing the demand on the court. We spoke about the civil side of matters as well. that is right now in Jamaica, 50% of civil suits are settled at mediation. So we are on the path of increasing the use of the non-high ticket items in terms of funding, because we recognize, even though we want a larger share of the budget, we recognize the challenges. And we are busy fixing our courtrooms. The outstations, for the most part, are just one-room places, right? So they do not match all the needs of a courtroom. As I was pointing out, the different challenges with security and weaknesses and so on and so on. So we are just making the best do we can with the facilities we have. And the technology that we are taking into the courts, for example, the outstations will be served by mobile units because they don't have the capacity for us to upgrade the electricity and all the various things that we have to do. They were made 200, some of them 300 years ago. They cannot come to the modern era of what is required in a courtroom. So, you know, those are the things we are doing. The Ministry of Finance has been kindly supportive to us in giving us the funding we need to deal with these lower hanging fruits. But the fact that we have major crime is our big problem. So we cannot not do anything, which is why we had to fight so hard for the DPP's office to get the positions it needs. The DPP's office cannot just take on any number of cases that come with a structure that was set so many decades ago. So we have low cash needs, but we have high cash needs as well. And there needs to be a meeting of the minds to deal with all of this. We will be submitting our budget in November, which will give us another round of initiatives that we are taking, trying to go a step at a time in light of what we can really expect to be provided to us. And if you'll permit me, sir, can I just go to the manual question that was asked that hasn't been answered? We have just received agreement from a proprietor who we've been negotiating with, maybe, Vivian, up to 3 years now. So we believe we are now at agreement, and we should be given possession of the place the 1st of November, at which time we will undertake the refurbishment works so that that can be provided as added facilities for the Mandeville Court. We have just gotten NCC approval for the rescoping of the Supreme Court, so that that is going to be upwards of $500 million to do the capital infrastructure improvements at the Supreme Court. And we are on our way with the work for increasing the availability of courts at the Court of Appeal, because that court cannot do any more than it's doing with what it has now. So that work is on the way, and we're about to move forward with the approvals we need so that that project can move on.
What will you be doing in the new facility or the rented facilities in Mandeville?
We will be first providing staff facilities, so the main court building, which we have done some significant works on recently, will largely be for courtrooms. And we are hoping
some of the administrative staff.
Yeah, all the administrative staff, we are hoping, and maybe to see if we can put at least 1 or 2 courtrooms in that space.
Okay, one of the things, Chairman, I see that's missing from the report is your financials, basically.
It's there.
No, I see where your salary is and all of those things, but what it is that the various expenditures, capital expenditures, and
I read that yesterday in reviewing the report again. Ooh. as at July was what it is. Can you find it for me quickly?
So I see
I
where
reviewed
you
that
give
yesterday.
you give us salary scales and things like that, but what was given to the ministry at the beginning of the financial year, where it is that you're at?
Oh man, which too many reports. This is the report that was sent to you July 5.
What page is that?
And pages 7, 8, 9, 10, and going on. Yes, expenditure under just all the different things, right? Yeah.
Well, I'm reading from
You don't have July?
the updated report that was sent to us yesterday.
No.
see anything
No,
inside.
the original
All right.
report that we submitted.
All right.
And then we were asked to provide these additional reports.
All right. Back to the outstations, and I hear Deputy Director. But why can't we do an assessment of some of these outstations to see, or have one been done, to see if the adequacies of what is needed, or what is needed for even a parish court? Because it seems as if everybody wants to be in the main town where these courthouses are. But if we can use some of these outstations and permanently just stage the parish courts there, then you'll have that additional courtroom in these main stations to run the circuit for whatever period of time.
That assessment is being done because the Chief Justice has indicated that she would like to have continuous sittings in the parishes. And if that is to be done, we will have to deal with the infrastructure of the courts.
You have St. Elizabeth as one, which
Balaclava, which is very underutilized by culture and resistance to change and protests of the stakeholders.
Resistance to change from the stakeholders for using Balaclava, hence why it is not being utilized as much as it should.
The population studies and the caseloads that inform the development of the Balaclava court was what determined what we placed there. And then persons say, well, you shouldn't have put that court out there. You should have put that court at Black River. Now, putting that court at Black River would not solve Black River's problem because it has one courtroom. So when the circuit will be sitting, there will be no opportunity for any other matter. Yeah. So that court could not have been the solution for Black River. Right? So we have all of that to fight with: culture, people's resistance to change, etc., etc.
Yes, thank you, Chairman. Through you to the PS. There were plans for the relocation of the Mandeville Courthouse some time ago. Are the plans still on the agenda? That's one. And secondly, the Ocho Courthouse and the K Valley Courthouses have been closed. Are there any plans for the reopening of those courts, and what has caused that delay? And thirdly, to the DPP, read the plea bargaining law, which was introduced in 2006, 11 years since then. We have not seen it getting off the ground or kicking. Why has it been lingering for so long?
Right. Chairman, the K Valley and Ocho courts were closed by the ministry. The use of the court was discontinued by the ministry because the courts were inadequate. They are heritage sites, well, as Ocho specifically. We would not be allowed to do the changes we would need to make it an operational court. And so the ministry at the time took the decision to discontinue the use of that building. We could not continue to be doing upgrading work on an inadequate facility. So the plan is to create a large facility in St. Anne's Bay. We have already gotten the land. We are busy pursuing public-private partnerships to move to construction. In Mandeville, we also are trying to settle the arrangements for the land which we acquired. We now have to do new drawings. Those drawings that we did not contemplate technology. And so that one is a work in progress. And also we're looking for a public-private partnership given the budgetary constraints.
Mr. Taylor will.
Yes. To the honorable member, the act that you referred to in 2006 has been repealed. It has been replaced by one that I think was passed this year, Plea Negotiations Act. Now, the first act, the 2006 one, was not user-friendly, at least for prosecutors. It had a bias towards defendants, and there was no sanction if you had entered a plea bargain and the person you entered the plea bargain with reneged. The prosecutor had to just, to put it on forensically, had to hug it up, and so on. So this new act actually now has sanctions for persons who have reneged. Now, although it is new, we have actually used it. We have been using it, not very often, like I think about 3 or 4 matters, but we have used in the gun court so far. And there are others that we are presently negotiating in the circuit court. So it is being used at the moment.
And it really contemplates the ability of the prosecutor to make recommendations in respect of possible sentences. This is in conjunction with a sentencing guidelines that will be formalized shortly, which the judiciary have settled. So certainly all my 44 prosecutors and I, we are actively trying to persuade people on that side, like Mr. Campbell, on the defense side. As an attorney, yes, defense counsel, you know, we call it the dark side, but yes, we love them still. We are the right side and the defense. That's just a joke between us. But, you know, I really sense in the defense bar the willingness to try to meet us halfway, because we will now both be able to consult actively, separate and apart from the informal plea deals that we can have at common law. But this gives us much more latitude to be able to discuss with defense counsel. Of course, bearing in mind what the victims would also require. Because what we do, if we are going to enter into a plea deal, certainly as prosecutors, we try to engage the victims or their relatives and get a sounding and explain the process. That is very important, because the pendulum of justice must swing in both directions, for the victims as well as the accused.
If I also may just add on to what the director has said, we have developed what we think we call a prosecutor's toolkit. So the new Plea Bargain Act is just one. So when prosecutors especially are going out on circuit, we give them the draft sentence guidelines. We give them the amendment to the Criminal Justice Administration Act, which allows for discounts in sentencing depending on when you plea. We also carry with us the practice direction issued by the Supreme Court on advanced sentence indicators. So we go there with all of these legislative tools and judicial guidelines to help encourage persons, if they are so minded, to plead guilty.
And our skills of persuasion.
Well, I thought the chairman was abandoning me altogether today. No, he isn't.
Chair, just to add a rider to what my friend has just said, in fact, it may very well require a cultural shift on the part of some of us lawyers, and of course the population which gets involved with the police, because we have this situation where a man is prepared because of the weaknesses in the system. I'll take a chance with the jury. So I think it's going to take some time, and perhaps our anticipation or expectation that it would be more, effective in the short term may not be realized. But aside from that, I'd like to ask the PS at this time. There's a number which keeps popping up in my head. Your judgments, the judgments which are recorded against the state, and I think the obligation falls with you to pay those. At the commencement of this financial year, where did those, what was the value of those sums outstanding?
At the beginning of the year, we had debt at 400 million, which is what was provided for in the budget. The amount provided was where the debt stood.
So basically, at the start of the financial year, you had adequate provisions to pay for the judgments that you had at that point in time.
Yes.
However, subsequent to that, you would get new coming on. And
however, our debt now stands at $915 million.
We had a bad 6 months.
Including interest, as at the 30th of September. Yes? And I might just say that includes a judgment which was handed down for just under 249 million, one judgment. So, yes.
So the norm, though, is that at the end of those provisions are made either in the supplementary or in the budget at the start
or
of the financial year.
unfortunately, sir, it is carried forward.
Yeah,
Yes?
carried forward.
Yes.
So you have settled that $400 million.
Yes, we've paid that out, and we are promised some more in supplementary.
But that is to deal with the additional 500 which has been put at your feet.
More?
Well, no, because it's now 900. No. This 900 is not inclusive of the 400. You with me?
No. Remember, what Chet said is that they had, at the start of the financial year, they had 400 in debt. And they received 400 in the budget to take care of all the backlog of judgment. In the period from April 1st to today, they have accrued another 900 million in judgments, which is not accounted for, which needs to go in the supplementary or the budget for the next financial year.
You pay interest at 6% per annum.
Or as the court dictates.
And would you be able to get private funding at a lower interest rate to deal with these judgments?
I don't know. The judgments, the money that we get comes from the government coffers, right? I do not know that we would be able to get loan. That would be loan funds to pay at a lower interest rate. I would have that investigated. I don't know.
Because I see you. Okay, we have matters which proceed through the courts, and
or awards made.
Yes.
Yeah.
Arbitrations or whatever.
Yeah.
And then you have you have interest running, say, for perhaps 5 years on an award which is made.
Well, not now, given that we were almost current when the year started. So our issues of interest running for long periods is not the same today.
All right. This 900 and how many millions you say?
15.
915.
If you round it up to 916, yeah.
916. And if you were to break that out, where would you say the majority of the judgments emanate from? Is it the actions of the police or the other state entities which have been delinquent in their duties, or what?
Traditionally, it has been the police. However, I must hasten to say when we have health judgments, those are much larger. So a single judgment for a health matter is far more expensive than several matters put together by the police. And the one I referred to is from a matter that occurred from 1995. And it is now settled in the court, and we have to find this money to pay. And as at September 30, with interest, that is $252 million.
And, where you have, let's say it were, you have this judgment for 215, whatever the figure is, and an officer who has been delinquent in the state machinery. Let's say it's a medical doctor. How do you treat with that medical doctor?
I am not aware of anything. What I know is that the police, they are required to contribute to the payment, and that is handled through the Ministry of National Security and the Attorney General's Department itself. I am not aware of any arrangements, agreements for other practitioners, public servants to make any contribution to the debt payment.
Could I just, Chairman, could I just finalize there's one little area that, that PS spoke to earlier, the relocation of the Court of Appeal and the Department of Public Prosecutions. Yes. Last year when the department appeared before us, there was, that property was supposed to have been handed over to the ministry for the works to commence, because I know that there was some relocation of the Accountant General's Department to that building at King Street, Lower King Street. Was there an allocation for the retrofitting of that building during the 16-17 budgetary year?
There is a provision for architectural and project management services of 45 million something, which is in our budget, and the building was handed over to us at the beginning of June.
Of which, this year?
Yes, June 2017. We went through the procurement process. The architectural firm has been engaged. The work is moving apace. We have sought to have the Court of Appeal first addressed with that expansion to allow them to have three courtrooms instead of the 2 they have, and to allow for sufficient chambers for the judges so that all positions as approved and enacted can be engaged as when the chambers are ready and the court so chooses.
When do you anticipate that the works will be complete?
We are, shall I say 5? We are imposing pressure on the firm, the firm, for us to have the Court of Appeal space ready by April. We are currently...
I take that to mean April 2018.
Right. We are currently finalizing a cabinet submission for the construction services to be acquired.
And may I just make one recommendation? I noticed that when you did the retrofitting of the NCB building, you had the civil courts were fitted with people,
jury boxes and
jury
so
boxes,
on.
and which I think is a significant cost. That all the parties be brought into the mix, because somehow I just think that people weren't speaking to each other when the work was done.
Well, I can't speak to that intimately, sir. I was not around. But suffice it to say, the current works and the DPPs here, we have engaged the users so that we can have proper sign-off for what is to be done.
Mr. Chair, with your permission. Two particular questions. I'm going to pick up on a question from my colleague regarding those settlements that are outstanding. You mentioned one PS that was started in 95
Yeah.
and is now settled. Is the settlement, settled as it's being paid out,
No,
correct?
the award, well,
The award
we
when-
were notified of the award in August, September.
This year.
Right.
Could you have any knowledge of what contributed to that long delay? And before you answer, I'll tell you background why I'm asking the question, because we had another committee that the matter came up about how long the state takes to settle payments. What contributes between 95 and now? That is 22 years.
Yeah, I would have to speak to the chambers. The ministry is not involved in that process.
The process.
We are only involved when the judgment or the settlement is
Well,
arrived at, and then it's handed over to us to pay
On
the
the
money.
surface of it, P.S., what concerns me is that where the state is wrong, that the offended party has to wait this long for a redress. So
Yeah.
it's different when individuals act in an interest, or even companies. When the state is the one who is responsible for this distress, it doesn't augur well for us as a country. So that's also an issue. As I said, it came up already in one of our previous meetings. But to the extent, though, that you're having these huge settlements by, say, for medical cases, any thought been given to ensuring, even if the state picks up the premium, and ensuring our service providers to mitigate against the impact of these tremendous costs? Because I'm struck by, we settled 400 plus million, and between now and this new financial year, talking just over $900 million in additional settlement. And what began to go through my mind is a more cost-effective way of dealing with these kinds of liabilities, which at the end of the day is the taxpayers who have to pay it. So I just want to, if there's any consideration in that regard. Two other points really to have concern with is the mention was made earlier on about the additional counsel for the 17 and 10 is to the DPP, right, as per the report. I've heard the complaints from some time about retention. But while we fill vacancies, while we create additional posts, concern in the back of my mind is the turnover rate. Because to fill them because they don't have enough position, but have positions going vacant because persons are either leaving or not coming in. Because the end result of additional posts is to ensure that the departments, in this case the DPP, that department, is adequately staffed to deal with the demand. So I would like some comments about our retention. What are the contributing factors, assuming it's low, right? If it is, what are the contributing factors? And can I answer another point that just slipped my mind? I'll come back to this. That was the third point I really had.
All right. The fact of the matter is that the attrition from the office of the DPP, to be specific, has a lot to do with persons being promoted to the bench. And of course, notwithstanding the level of remuneration that is payable. So persons leave, I think far fewer, the DPP can speak, far fewer leave the public service, but the recruitment for the bench, a high proportion is taken from the office of the DPP.
So the bench is your main drag on the DPP? My words.
Well,
Not that I'm complaining.
I would say, for example, in the last 2 years, we have released, by the end of this year, 10 senior prosecutors at the level of assistant director and deputy director to the bench. Yes, it is promotion in terms of, making sure that your potential as a legal officer is fully realized. But some of the driving factor in respect of resignation to go, for example, to be a prosecutor in other jurisdictions or to be a judge has to do with the remuneration. I am going to say to you, gentlemen, because I think you would be shocked to know that although it is only the DPP and the Auditor General who have entrenched positions in the Constitution, and I think the judiciary, in fact, the DPP is the only other legal officer other than the judiciary who is entrenched in the Constitution. So the DPP is not a commission of parliament like INDECOM or the Children's Advocate or the Contractor General. And the DPP is paid much, much less than the Children's Advocate or any of the commissions of parliament. So you can imagine, just a moment, we're looking at responsibilities, because none of the commissions of parliament can dictate to the DPP. In fact, Parliament itself, unless it's by legislation, can dictate to the DPP because of Section 94, subsection 6. In fact, under the Constitution, no one can really interfere with the exercise of the DPP's discretion. So if it is that the DPP is paid so much less than the commissions of Parliament, can you imagine what the rest of staff is paid? So naturally, and I think it's also happening at the AG's office, naturally, it is a big drive when to apply to go on the bench. And I'm very happy for my colleagues because it is good to see the bench being repopulated with officers who have a Pavlovian instinct for the criminal law. But it is very concerning because in so many areas of national life, you need to have a certain level of experienced technocrats. The DPP not only prosecutes, but I'm the designated central authority for mutual assistance. I can tell you, gentlemen, that my head of mutual assistance unit, Ms. Maxine Jackson, deputy director, just attended a high-level meeting in Austria, Vienna, in respect of meetings of the central authority. And I got a congratulatory note from the chairman of the meeting because Maxine was the only representative from the Caribbean in terms of the central authority representing me, and her interventions and her advice were so respected that it put Jamaica on the map as a small country in respect of the value that was brought. Now, if you don't have that level of expertise and experience in terms of mutual assistance, which is so critical in respect of governance worldwide, then Jamaica would be embarrassed. As simple as that. So, within certainly the Ministry of Justice, in terms of these specialist departments, you need to have the retention of a certain level of experienced technocrats in order to make sure that the work of the administration of justice carries on apace.
I can appreciate that, but, with all due respect to someone who have served in the executive myself, I have to deal with the question of remuneration across not just the public service alone, but particularly in the legal services. I know there are other areas of the legal services that have that crying need for remuneration in order to retain the expertise that reside there for the benefit of the country. And it just speaks to, quite frankly, to be blunt, regardless of which administration is in office, it's a question of adequate resources to deal with the personal needs, not desires of the country. So I can appreciate that, having been in another place at another time. I asked a question just to enlighten my own appreciation for what the current circumstances are and the extent to which it impacts upon, our judicial legal services generally. And just in closing, a passing one, you mentioned about those positions which are provided for in the constitutions. They are in the Constitution. There are others too provided in the Constitution, which
Not
the
legal.
remuneration is so glaring.
Yes,
that
but it's
you
a
wonder
difference.
why
It's a
they
difference
remain.
of
No, you wonder
function.
why they remain in much the same way we wonder why you remain.
Well,
But your loyalty to country.
Well,
I
it's a
think, is
commitment
what-
of
is what-
service above
is
self.
what
But
drives.
but the thing about it is that in terms of the functions, part and parcel of the ethical remit, yes, the ethical remit of well, I certainly wouldn't want to go on your side. No, but seriously, luckily the administration of justice, whether at the level of the permanent secretary and a lot of members of her staff, the judiciary, even defense counsel and certainly prosecuting counsel, you have to have a commitment to service above self, to serve your country and to give the best of what you have. But at the same time, the fact of the matter is, you need to recognize that if you don't have technocrats at a particular experience level, then the authorities are going to be shortchanged in terms of getting the appropriate advice on policy and a lot of other matters. Luckily for me, I have an embarrassment of riches in terms of so many people wanting to come and join the office of the DPP to partake in the vibe that we offer and of course the learning. However, it takes 2 years at least if a clerk of court comes up to our office, 2 years of mentoring and training before that person can go out and man a circuit court. Because remember, unlike defense counsel who may be going to a circuit with 2 or 3 cases, for the 300 cases or 200 cases, it is the prosecutor who has to prepare every single case, prepare the indictment, liaise with the police officer, do the legal research in respect of every single file. And the judgment that you have to make, it comes from experience. So
No,
that is it.
the other question which I'd passed my mind. Deputy Director had mentioned.
Before you move on to there, just because just looking back at the report, that the additional posts, have you gotten instructions from the Ministry of Finance to?
Oh, the day after I expressed my frustration, the organizational review approval came for posts to be added to our establishment.
How long it took you to yeah.
Well, you know, I don't think, is it part of the problem, which is why I was so frustrated and why the permanent secretary joined in my frustration, was because the office of the DPP had been engaged in an organizational review scenario with the Ministry of Finance, with a particular department there, for at least 2 years before. And you know, that is a long and involved process. Because we knew of the emergency situation that we were in last year, we decided to do a justification through the permanent secretary to the Ministry of Finance to ask for these posts so that we didn't have to await the organizational review, which was also looking at our structure. And this is what the minister and the permanent secretary carried to cabinet, and we got approval. And our budget was also supplemented. Again, the permanent secretary made representation. So it was quite clear to me that this was a situation where the particular technocrats didn't understand why it was that it was an emergency. So they could have simply given us the post pending the completion of the organizational review.
It was a matter of emergency too. License number 5367 GE. If anyone in here drove that vehicle with that license number, a window is open.
What is
5367 GE.
Okay.
So, I didn't know about seeing the coin. I remember, in all fairness, your minister
Yes.
came here and cried, and we sympathized with him and gave full support and endorsement. So maybe that's why you got it. You got unanimous support when he came here crying. We we felt his pain, and we heaped our support behind him. But anyway, the other substantive point, Chair, is Deputy Chair, you had mentioned about the plea bargain and your toolkit that you use. I have a particular interest there, Chair, because I really believe that if we can get that going, it's supposed to impact enormously. In another life, in Ledgecombe, there are other legislation. Another legislation provisions were made to facilitate that kind of thing. Point is, I heard what you said about the toolkit. I would like, if there's anything more, to tell us what more can be done, or to be done by us, the state, that could propel that process more. Because I'm convinced that with the courtroom shortage and much of those other issues, if we can get more cases disposed of to mutual agreement, which is what plea bargain is all about, basically, then you release the pressure. This whole thing about crime and violence in the society and all of that, it's all intertwined. So I am really making a plea here now, right? To help us, tell us what is it that we can seek to have done that can really get the plea bargain process more entrenched. Is it more public education? Is it more what? I don't know.
It is, in fact, member, to respond where that is concerned. One of the members previously made mention of the need for a culture shift, and nothing short of a massive culture shift is going to give us the desired results when it comes to full acceptance of plea negotiations and really getting into the minds of defendants and counsel too, but especially the defendants, that it is okay to enter pleas of guilty. This notion that you can take a chance, and as it is often said on forensic language, sometimes they have this view that we can bust the case, so you're just going to ride with it. And sometimes even, and in fairness to some of the counsel at the private bar, even at times when we have had intense negotiations, and as counsel on both sides, it is well accepted that what is proposed is acceptable, because when one considers the weight of the evidence and where you have witnesses available, as far as we are concerned as counsel, the question of the verdict is almost the inevitable, going to be guilty. So we say, in order to minimize the waste of the court's time and resources for 3 weeks when there's so many other matters in terms of backlog to get on with, by every means enter a plea, and we find the legal justification where we need to find that legal justification for accepting the plea to lesser offenses at times. And notwithstanding sound advice from defense counsel, you have a number of attorneys who will come back to say the defendants insist we are going to trial. Only 2 weeks ago, personally, while in the home circuit court, having been in lengthy dialogue with very senior defense counsel for what might have been about 6 weeks, because as prosecutors, and this is counsel who used to be in this house too, very experienced, the initiative that we have been seeking to implement in the office is that even before you start your stint before a court, you engage in the dialogue and the negotiation with counsel. Having looked at your cases, examined the files, you say, listen, here is a matter that has been on the list for a certain amount of time. The witnesses are ready, but we are prepared to accept a plea in this regard. Will you speak to your client? And despite all the time and counsel speaking with this defendant for at least 4 different court dates when the matter was adjourned. We even empaneled a jury, because there are times when that can sometimes, the urgency, it can jerk that willingness and that consciousness to say, you know what, let me throw in the towel. None of those moved this young man. He insisted on the trial, so we insisted on finishing it. And of course, when the guilty verdict to murder came, he then turned and was asking his lawyer in my hearing, me can still get the manslaughter? No, I'm just telling you in terms of when we say a culture shift is needed, and I want to make it clearer.
Or wouldn't you say that lawyers also contribute to?
I wanted to add that separate and apart from the lawyers themselves as we know it, those who go to law school, there seems to be an esteemed panel on the inside. Yes, there's an esteemed panel on the inside of where custody persons often are, for example, and even those on bail. Those persons are esteemed Queen's Counsel. So very often, outside of the sound advice of their defense lawyers to plead guilty, these persons are insistent because their cohorts on the inside say, no, don't take any plea. And then at the end of the day, the result is what it is. I would say, just to add in conclusion and put it in context, a tremendous culture shift, massive public education. Some time ago, I recall hearing and resources being put into this. I recall hearing the minister saying that he was going to have a pamphlet done to be put and made available to all defendants so as to ensure that they are aware of what can happen in terms of sentence reduction and that they will come the full distance in terms of pleading guilty. But the defense bar needs to hold our hands, and we are certainly willing to hold theirs, and we're working together.
Just out of curiosity, Chair, is there
Last question?
Yes, just out of curiosity, are the legal fees less for trial than for plea bargain?
I'll protect you from the chair. I'll protect you from the chair.
I think, remember that we know how it is. We know how it is. But in yes, Mr. Campbell would be best positioned to answer that. But in fairness to the private bar, I will say, as I think the director said, I believe that we have been experiencing with great sincerity, a greater level of cooperation from the defense bar in terms of using the different legislative strategies to try and have some of these matters removed from the list without the need to go the full distance of a trial.
Mr. Chair, we're directed to the PS. Now, you all are in the fraternity of the administration of justice, either at the courts, the bench, and the private lawyers. You talk about education. There are two basic audiences, that in the legal fraternity and the public at large, a non-legal one. My question is, these discussions take place in that fraternity of legal practitioners. That's one part. And the second part, Madam PS, this public education that has been made reference to, who is going to lead it or who should lead it? Because having recognized the problem, the question is doing something about it. The recognition of it doesn't make for a solution.
But I don't think the culture shift is only for the defendants, but also for the bar itself, the lawyers themselves. Hence, coming back to the outstation, when you spoke about culture shift, I guess it has to do with also those who utilize the facilities. Madam, yes.
I'd indicated to the chairman, member, the Ministry of Justice is responsible for the public education program. We launch our round of public sessions on November 2 at the St. George's College at 6 p.m. We will be preparing booklets, and we will be doing billboards and posters that the Chief Justice has already agreed to have mounted in our courts. And the slogan is, plead, don't gamble.
Put up any in the jail cells too, because...
we would think about that, because you see, that's not really our sphere, so we would have to ask about that. And also to point out that the judges' seminar is this weekend, where the judges will be doing their stuff, looking at the legislation and to make sure they are fully on board with it. We will be doing a session at the bar conference in November as well for members of the bar. And in fact, then the representatives from the National Center for State Courts out of the United States is coming for that session at the weekend. And the DPP, I am now in receipt of the sentencing guidelines, and the ministry is moving apace to have it published. So I think we've covered all our bases to ensure that plea bargaining is set and start running, and we'll have an opportunity for real success.
That's good news. All right, let me
Add to that we are having a seminar, the Office of the DPP, the first weekend in December, where we will be having a role-playing scenario in respect of how to deal with the plea bargaining, with Defense Counsel participating as well. So it's really all hands on deck. The will is there.
Okay. Let me thank Mrs. Palmer and the team. I think we will see you in another 2 weeks with the other arms of the ministry so that we can wrap up the Ministry of Justice. Thanks, everyone. I think we as legislators would love to see this ministry looking sexy as DPP. Yeah? No, seriously, I mean, you know, when in a similar instance when the Ministry of Health came here, we got a wake-up call also, and this itself has been a wake-up call. But we, as the substantive chairman always describes to me, that, you know, it is better to have a pretty woman than an ugly woman. Eh? So let me thank you again. I think they're all pretty, inside and outside. But all right. Any other business, members? No other business.
Thank you very much, Chairman, for having us.
Thank you. Meeting adjourned.
At least nobody will say you're gonna do your work. No, but it's on the screen. It's on the screen.